I can understand that.
Yes, sir.
I can understand there came a notification that this meeting is recorded, so I was accepting it. That's why there came a glitch. Well, I understand that a person like you who is very busy, right, and that too on a Sunday morning when you have to look after your family also. But despite that, you are here with us to motivate us and to inspire us. That shows your commitment towards your profession and towards your institute and towards your work. So thank you for providing me this opportunity to interact with the learned colleagues from different colleges of Haryana and other parts of the country. I just saw the chat box and found that there are people joining us from Tamil Nadu, from Bareilly, from different parts of the country. It is very heartening to note and very motivating for me at this juncture when I am just an assistant professor and I'm getting this opportunity through you. But mind you, ma'am, this will not give you any circumstance or any occasion of disappointment, because I am a subject expert of my discipline. So I will be helping and learning from my colleagues different things through this platform. Thank you very much, Dr. Kiran Angra, Principal M.D.S.D College, Ambala, and Ambassador for the NAC accreditation for the state, I believe, for Haryana state. Or is it for the entire country? I don't know much about it. The ambassadorship, it is only for the Haryana?
No, sir. It is a national
Okay.
appointment. Yeah.
Okay, fine. Fine, ma'am. Fine. Got it, ma'am. So let's talk about the business. We have gathered here to understand very interesting subject and very relevant subject, which is intellectual property. We all work in different institutions in different capacities. I mean, since most of you are from the field of academia, as I can make out. So our job being an academician is not only restricted to teaching our classes. We all have understood the role that we play in making the institutions, in the corporate life of the institution, and to take our institutions at a very higher level, where we get recognition from the national authorities like NAC, or we also become institution of eminence, etc. Or we also aspire to get or fetch the slot in the 500 IQ ranking, or other different sort of rankings for the institutions and for the universities in the world across. So our role as an academician is not at all restricted to just teaching or imparting teaching to our handful of students sitting in our classrooms. It goes beyond that we all understand very well. But the issue is that most of the times, many of us who probably have not got that kind of a training which is required for the same, we face difficulty in, we have those.
But
am I audible, Dr. Anuradha?
Yes, sir, you are audible.
Okay, there came again a glitch, but I am audible. Thank you. So many a times we see that we, irrespective of the fact that we have those requirements and achievements or the requisites, right? But we could not able to procure or put them on record to fetch the accreditations or to fetch the requisite, you may say the laurels for particular institution. So my talk today would partially be to tell you about what is intellectual property and how intellectual property is important for the academic institutions, because the house involves and comprises very learned and senior colleagues. So I would be assuming that many of you already know what is intellectual property and how is it important for an academic institution. But I would try to incorporate the industry perspective as well as the academia perspective, and then would mold my talks to make it helpful for the audience here. And partially I will talk about the copyright management in the academic institution in the next half of the today's session. So let us begin to analyze how industry and academia, these two different contradictory, you may say, uh, separate regimes altogether, they can combine and they can run in tandem towards a common goal, right? And the goal is ultimately to catalyze innovation, to catalyze, technology, or to prosper, basically, right? So this is the common goal towards which both the institutions run in tandem, but they seemingly look parallel institutions, or you may say having no commonality. But the fact is that these two institutions, be it the academia on the one hand and the industry on the other hand, they run in parallel, they run in tandem, right? Sorry, they run in tandem, not parallel, right? Because their ultimate goal is to achieve the broader objective of catalyzing innovation and technology to be prosperous in the respective disciplines and to help each other in one or the other way. Our country specifically, we lack this coherence among these two seemingly different regimes, or you may say seemingly different institutions. There's a fundamental problem when it comes to their collaboration, their working together, and we all face that. Not only us as an academicians are facing it, even our counterparts in industry, they also struggle to collaborate with academia. And that's where the whole issue lies, that there is no model practice through which we collaborate, right? There is a lack of model practice, and that model practice is very prevalent and very advanced and developed in foreign countries, in developed jurisdictions, specifically like US and Europe. These jurisdictions like US, China, and Europe, their whole intellectual property regimen, or whole intellectual property system framework is primarily or predominantly based on the academia, right? Unlike our country, where the two separate institutions working in silos and rarely come together to achieve a broader objective of catalyzing on innovation and catalyzing on you may say technology, right? But if we do a case study of these nations, these jurisdictions like US or China, who are pioneer in intellectual property, they are the major intellectual property hubs in the world, right? China is also taking lead. It is a front runner now in the Asia or in Asian region. We are very you may say on a very lowest rung of the ladder when it comes to our intellectual property creations and our intellectual property filings and our collaborations with industry, or vice versa, right? But these nations like China and US, they have the best models available of collaboration between industry and academia. I would tell you the statistics specifically of US, where most of their patents filed by the industry, or for that matter, individuals, they originate, or originally they have originated from the academic institutions, right? They have only been capitalized, or you may say have been facilitated by the individuals or by the industry. But most of these intellectual property which are over there, or which are protected over there, or their IP assets, they originate ordinarily from the academic institutions, because they have a best model available of collaboration, unlike our country. China is another example where all the same statistics we are getting, or we have the same statistics available, where the academic institutions and industry are coming together. Most of the ideas, you see, they originate, or you may say they generate at the academic institutions, or at the level of the educational institutions. They may be reaped later on by the industry, or their fruits may be yielded by the industry later on. But idea generation and then molding the idea or maneuvering the idea for the purposes of fetching the patent, or making it worthy for fetching the patent or any other intellectual property protection, that happens at the industry level. That is how they work. And within this framework of industry academia collaboration, we find in India specifically a very major problem. As a law scholar, as a law teacher, I see that neither the models are available of collaboration, right? There are some steps taken in this regard by Ministry of Science and Technology, where they also came up with the framework of collaboration between academy and industry in year 2019, right? Which certainly brought some momentum and which heralded some sort of collaboration between academy and industry. But that has still, that has still remained at a very higher level, or you may say only the educational institutions, which are the topmost educational institutions in the country, like IITs and IIMs, they have been able to fructify it, or they have been able to somehow cashify it, right, or encash those particular models. But the small institutions like the colleges in Haryana or other colleges in other parts of the country, I don't see that much momentum has come at their end, right? But the scheme is applicable or is available, or all the institutions are beneficiary of the scheme. But we don't have that kind of a mindset or mental frame, or you may say the exposure, where we can also collaborate with the industry, even with our petty ideas, or you may call with the utility models, or with the small helpful ideas, which will gonna, solve some critical issues or problems in the society, right? But the issue is that neither the models are available, neither the models are taught to the faculty members, or they are exposed to those faculty members. They have not undergone any such training, nor we have model contracts available. The second thing, which as a law scholar I see, which is problematic, is that model contracts are also not available. There has to be some formal contractual arrangement between the academy and industry. MOU is one thing, right? Entering into an MOU is fine. But when it comes to intellectual property appropriation and its utilization, when it will be commercialized, or sharing the benefits of the IP created by a joint endeavor of academy and industry, we certainly don't have any, model contracts available. Always we face a critical question of who will own the intellectual property in this kind of a joint endeavor. Is it the academic institution which will own the intellectual property, or the industry will own the intellectual property, or this will be a joint intellectual property? I myself have faced this critical question and challenge when I was working or endeavoring to collaborate with the industry on one of my projects. My idea was to to help the industry and to take their help in return or in reciprocation. But I faced a very major issue in collaborating with them, because they insisted that the IP will remain with them, right? But this is something, no academician or no individual who has applied his intellectual creation or intellectual labor and efforts to create something would ever discard his IP to them, or would ever try, or be happy to give their IP to them or intellectual property to them, right? These are some of the challenges which we face. But if we have model contracts, model non-disclosure agreements, model, you may say, practices or platforms available, we can certainly achieve this objective. Every time, we also face, I being the director of one of the clinics, as Dr. Kiran Angra mentioned in my introduction, this clinic is meant to help the budding entrepreneurs and you may say people in the MSME basically, who take our counseling. They always come up with this critical challenge that the industry is saying that they will keep the patent, they will keep the trademark, they will keep the copyright. Even our books which we author, every time the publisher takes the copyright from us, and we do that, we do give up our copyright to them. We never resist, we never insist on retaining the copyright, despite the fact that we have created that work. It is this kind of problem which is perhaps or undoubtedly, not perhaps in fact, which is undoubtedly creating so many hurdles for this collaboration of industry and academia to take a very giant shape in the country, to produce good work, or to catalyze or monetize the different kinds of intellectual properties, in the field of innovation and technology. So I hope that these are some of the issues which are somehow triggering, and all of you must be facing. So with this brief background of about the industry academia challenges that we face, I would jump to quickly tell you, because there are many colleagues to my understanding who are certainly in the gestation period of creating the different kinds of intellectual property, or they must have already created some intellectual properties, but because of the sheer unawareness or ignorance, sometimes they don't uh, uh, capitalize those things or commercialize those things. So it is very important to understand the contours of intellectual property, the different dimensions of intellectual property. Once you understand those, as well as understand how to commercialize, how to monetize, as well as if you understand how to collaborate with the industry, it becomes very easy or very fruitful for you to capitalize your work, to commercialize your work, as well as to ultimately contribute into the broader objective of you know prosperity, right? So let us begin with understanding what all kinds of intellectual properties which are important for the academic institutions, and how are they to be utilized and exercised or commercialized and monetized. This is important aspect, this is an important facet, for which I would like to share my screen quickly, where I will be cursorily telling you about the different kinds of IPs. Though I assume that the learned house already knows some of the IPs, patents, copyright, but the point is, the things that I may be telling you may perhaps be new for you. I will not only tell you what is copyright, I will also tell you what kind of a different rights which are available to you, or when you create a work in the form of an invention, what can you do being an academician or at an academic institution to monetize and commercialize it, and to finally fetch a patent protection on the same. And then this whole exercise would ultimately go to the main point of NAC score, or NAC accreditation, or institutional corporate life, etc. So let us begin with having a cursory look at some of the important intellectual properties. I hope the screen is visible to all of you. So देखो, I have jot down or put down very basic things, what intellectual property means or refers to. These things are creations of mind, offshoot of an intellect, or result of thought and intellectual activity. It may be anything, right? It may be a literary work, it may be an artistic work, it may be an invention, it may be an industrial design, it may be a cinematograph work, it may be a computer program, and so on and so forth. Because academic institutions in the country are multidisciplinary in nature, and they have scholars and researchers working in different disciplines, right? Some of them are working in computer science, and some are different, working in sciences, some are working in social sciences. So all of them have you may say, a great potential so far as their works are concerned, to fetch intellectual properties or respective kinds of intellectual properties. So these are basic you may say the basic things on your screen, which may perhaps tell you that intellectual property is basically an intellectual creation of a person. And then I have given you example, it may be anything, an image, a logo, or a computer program, or a chemical formula, or any cinefilm or music composition, etc. Why do we need intellectual property? For that, as I have already told you, that IP has an economic significance. It serves variety of industries, including information industry, entertainment industry, manufacturing industry, pharmaceutical sector, and so on and so forth. These are just indicative things. Then why intellectual property matters? So that also is something, very discernible and comprehensible by the learned house here, that IP is very lucrative. It is a key business asset. It acts as a IP a marketing tool, or for with goods and services. It spurs economic growth, right? This one is really very important, that it spurs economic growth. I gave you an example of two jurisdictions and two destinations, US and China. these two economies, including Japan, right? These three economies, in fact, they they had prospered or reached to this level of development mostly because of the intellectual property acquisitions or intellectual property creations, and their economy has a huge contribution. The overall economy has a huge contribution of the intellectual property alone, right? But on the contrary, in India, the intellectual property's contribution is minimal, right? Because when we see the filing or the number, the statistics, 80% of the patent applicants today in India are foreigners, are multinational companies. Indigenous or local applicants or domestic applicants are only 20%. And these 80% are just applicants. How many actually get, or these 20%, rarely get the patent protection because they are just applicants. The fate of their applications or their particular patent claims is later determined when their applications are determined fully or disposed of fully. So hardly 5 to 10% of the total patent filed in India are the domestic patent applicants who get the patent protection at the end of the day. But most of the, or you may say the 95% or 90% of the patent applicants are multinational companies, or you may say the foreign applicants, right? So that is something very crucial for us to understand in the academic institutions, that we have ideas, right? Bharatvarsh has always been, history, tells us that we have been pioneer in several things, right? It is just a matter of understanding the potential of a particular creation or intellectual offshoot of yours, and then capitalizing it, or then collaborating with the industry if there is a prospect of collaboration, or commercializing it if there is a prospect of commercialization, right? Then rest is the story of success. You all understand it. Then it is also something which gives the recognition and fame. These are the simple things. Well, so far as the introductory part is concerned on the IP, as I promised that I will be telling you different legislations or different kinds of intellectual property. So I tell you that Copyright Act we have of the year 1956, we have Patents Act of 1970, we have Trademarks Act of 1999, we have Designs Act of year 2000. This is called Industrial Designs Act. We have Geographical Indications Act of 1999. We have Plant Varieties and Farmers' Rights Act of year 2001, and Semiconductor Integrated Circuits Layout Design 2000. So there are these 8 different legislations or laws in the framework of intellectual property, or in the broader framework of intellectual property in India. Well, these are compatible with the international practice, or you may say the in consonance with the international practices prevailing across different jurisdictions. And the reason for this commonality or uniformity is the Agreement on Trade Related Aspects of Intellectual Property, or you may say the WTO's TRIPS agreement, and which we are signatory of as a nation. We have the obligation of having these laws or these particular recognitions of different subject matters or intellectual properties, be it copyright, patent, trademark, design, GI, plant varieties, or semiconductors, right? So if you move ahead, I will show you different types of intellectual property with certain examples, right? Patents, trademarks, copyright, GIs, or industrial designs. Patents, we all understand that these are products and processes. The legislation on patents, this 1970 Act of the Indian Patent Act, basically, it tells us that the products and processes are patentable in India, right? Basically, the inventions, right? The new inventions, I must use the word new inventions, they are patentable in India. The products and processes is the further classification within the new inventions. You may stick only with the word new inventions. The discoveries are not patentable. We all understand it. It is the inventions which are patentable. Most of my colleagues from the sciences, they understand that mere discovery of a naturally occurring microorganism is not patentable. But if a microorganism has been created by an individual or a scientist which is non-naturally occurring, then it will get a patent protection. It is worthy of patent protection because it is a product, right, within the definition of the new invention. which is worthy of getting a patent protection if it qualifies the requirements. There are further requirements which I will be speaking a little later. So this is an example which is a very funny example. It is just a snowboard, you know. We have a physical education also in academic institutions, and physical education teachers or professors or, you know, tutors, they at times also create certain, you know, you may call the products or invent some products to facilitate a particular sport or an activity, right? So they can certainly get a patent protection on their those creations. It is a matter of just identifying and, you know, understanding that getting a patent is not a rocket science, or it is not always required that your work has to be a rocket science. You may you may get a patent protection even on a small creation of yours which helps to solve some long standing problem, right? Helps to solve some long standing critical issue. That may be a very petty thing for that matter, but since that has not been anticipated before, that has not been publicized or has never been in use before in you know, India or abroad, right? Then it qualifies for the patent protection at the outset. Similar is the example. This is just a specification. This is again another example of a patent. This is ice resurfacing machine, right? It was awarded a patent protection in year 1953. So these are some of the illustrative things for the purposes of making you understand that these are the things which may also get the patent protection. It is not always, you know, the chemical composition or some rocket science which will be worthy of getting a patent protection. Small changes, small help, you know, small additions or improvements, small workshop improvements in certain things which are not anticipated, which are not obvious, which are helpful in solving critical issues or problems, or which are helpful in giving some you know, efficacy to the particular product or a process, which are certainly, you know, helpful in giving some sort of technological advancement, right? Industrial application to a particular product or process. That can be a worthy thing for a patent protection. But the point is, you usually do all these things, but you don't understand, and that is because of the lack of the particular awareness, you know, that it is something which can certainly qualify for a patent protection, right? There are processes, examples like a process of making pharmaceutical composition, or a process of you know, composition of any chemical composition, etc., right? So there is an example of trademarks like these logos on your screen. These are the examples of the trademarks. These are mere logos, but they serve a very great purpose. We in the academic institutions, when it comes to academia, we create sometimes, you know, several logos. Like this M.D.S.D college, Ambala, it has its own logo. So is the case of other institutions in Haryana or in the country. You know, they have their own logos. Their different centers have their own logos. Their different departments have their own logos. If they have their own logos, and if they are providing certain services within those, you know, like educational institution is providing educational services, right? So we qualify for the protection of those things, but we are not mindful of these things. Similar is the case of, you know, your invention which you seek a patent protection for. You may tomorrow give it a name when you will commercialize it, but you need certainly a trademark to indicate that this is a product which has originated from this and that source. So you require to give it either a name which will be a word or a letter, or a logo which will be your creation, or some device you will attach with it, or affix with it, right? Or a tag which you will affix with it, etc. So all these things will become a, you may say, a trademark. Broader details about the trademark patent I'll be telling you in the next 4 days, but these are just examples to make you understand. These are the examples of the trademarks. Then in the copyright, you know, we have excellent examples like a photograph, a mere photograph. In the academic institutions, in the universities, in the colleges, our students, we generally click certain photographs, or sometimes while involved in some sort of a project, we collect or collate a lot of pictures, lot of photographs we take, etc., right? Those photographs collected and, not collected, sorry, those photographs taken by any of the researchers or any of the scholars or any of the individuals, even they are in the academic institutions, they qualify for the protection of the copyright, but we don't understand it. We never claim any copyright. We leave those photographs into the public domain for the public utilization and public usage, right? But mind it, and let me tell you that this is not allowed. It is your copyrightable work because it is you who have taken that photograph. What the law says on this, the copyright law categorically says that the person who clicks the photograph is the owner of the copyright. So if you have clicked any photograph of any sort of a, apparatus created by you, or any research where you have done a field work, etc., of the things, of the places, or of the people out there, then those photographs are your creations. You own a copyright on those photographs. So similarly, in the academic institutions, there are several other kinds of works like paintings, or we create in the specifically in the departments of arts, where drawing or art or these things are taught. You create a lot of work, right? So the author or the institution under the aegis of which the work gets created is copyrightable if it is a painting, right? Undoubtedly. But we usually don't claim such kind of or assert such kind of rights. This is again a photograph, literary work. We author the books. We all understand, right? And I told you in the beginning that we always give up our copyright to the publisher. But I would say, as a copyright law, law student and copyright teacher, that we must not do that, because when we give our copyright, and what if tomorrow the particular publisher, he concludes the contract between him and us, right? What if the publisher says that we need to now you may say that get this work reviewed or renewed from someone else, some other author? Since you don't own a copyright, you can't do anything. I hope you understand it. But many of us usually give a copyright to the publisher, and we never say no. And the problem is that we feel that it's fine to give up a copyright, because copyrights are generally not considered very lucrative vis-a-vis to the patents. We are very serious about the patents, but not about the copyright. But let me tell you, copyright is one such industry, or sorry, one such particular kind of intellectual property, which has a huge contribution into the overall GDP of the intellectual property alone, right? The entertainment industry primarily runs on the copyrightable works. The media industry primarily revolves on the copyrightable works, right? So it is also something to be respected and to be, you may say, given the due weightage and due importance. So my dear colleagues, please don't ever give your copyright to the publishers, though there are publishers who always demand it, and usually we give them, because we need our works to be published. And this culture in the country has gone so deep, and you may say has taken a so robust shape, that it is very difficult to break this kind of a culture. The publisher takes it as granted, that copyright will remain with me, and the author usually takes it as as if it is not his right to claim or assert the copyright. But my dear, I'll tell you that many a times I have seen such such authors struggling to stop the publishers by making unaccounted money on the basis of the work of someone. They make unaccounted money. They take a copyright from us, and once they take a copyright, all the rights which accrue to a person owning a copyright will lie to the publisher, not to you. Like the right to reproduce, it will not be your prerogative to determine as to how many copies will be reproduced of your work. It is the publisher who enjoys the copyright. Now, when you have given it up, he will determine as to how many copies of your work will be created and will be generated or reproduced tomorrow. You can't do anything. And he may tell you that only 100 copies were sold, or 100 copies were printed, or 500 copies were printed initially. You can't track your book going into thousands of hands. You know, you don't even get to know because there is no transparency from them. So it is requested and urged because we have this common concern when we author the literary work, right? I urge to all of you and request to all of you to kindly assert, or at least assert for the joint ownership of the copyright. In case if you are not able to bargain or to get the full copyright protection, at least assert for the joint ownership of that work. Then there are other works like sculptures or sound recording in the academic institutions. We have uh, in arts departments or in music departments, where the work like sound recording or compositions, etc., are also created. So we must be mindful that those works are not petty works or are worthy of the copyright protection. They are copyrightable. And one important thing, or one beautiful thing about the copyright regime is that it is an automatic protection regime. The moment you create a work, the copyright gets conferred on you. You don't need to rush to any, you may say, uh, institution or office to get the copyright protection on your work. You get it conferred automatically, but that does not mean that you must sit idle and not apply for the formal copyright certificate. You should always do that, because the formal copyright certificate becomes very handy for you to capitalize or you to contest in case there happens any copyright battle tomorrow, that it is your work basically and for which you have already granted a copyright protection by the copyright office, right? So I would suggest that you, when you create any of these works specifically under the copyright regime or in the patent products or processes which you think are new, are patentable, or are meeting the patentability criteria, which I will be telling you in my next sessions, maybe day after tomorrow and after that, because I have one particular session on patents and the protection of the patents and its scope. And so is the case of copyright. For copyright, I will be telling you a few things in detail today only, because second talk also I have kept with me because of the unavailability of the first speaker, who is because of the shutdown of the internet is not available to speak today. Unfortunately, in his state there is some exam going on, and the state administration or perhaps the district administration has shut down the internet services, so he is not available with us. So I will be telling you more in detail, about the copyright protection. So we have another example like performances, right? And let me tell you that in the academic institutions, all these extracurricular activities where students, teachers, they perform, they do some performances, right? Those things are also copyrightable. We do usually think that it is only the big celebrity, who get a performer right, like a celebrity of the stature of Shah Rukh Khan or other cine stars. No, any individual, me, you, or any student for that matter, whosoever is performing, gets a performance right on the work. It is not only available to the privileged class or to the cine stars. So mind it that whenever any such sort of work or a performance is being made in any of the festivals or any of the competitions in the academic institutions, they are worthy of the copyright protection, right? And cinefilms, like in digitized world where we live today, this fast technology laden world where we live today, we see that every single person is holding a portable computing device called cellular phone, and it has become very easier, drastically you may say dramatically easier for any person to make a cinefilm, be it a short cinefilm or a long cinefilm or a small clip of 5 seconds or 10 minutes or 5 minutes. The length or the duration of the film or of the visual representation or the visual work will not make any difference. Neither the length nor the artistic merit or the cinematic merit of the work will make any difference. Even if it is bunkum, even if it is bogus, still it qualifies for the protection under the copyright regime. So my point is that in the institutions now, the students or the researchers or the academicians who lead the research scholars, they at times make small films, some clips, some cine films. Different disciplines have different requirements. Their works, those cine films, be they are very short, be they are of 5-10 seconds or 5 minutes or 10 minutes, be they are, you may say, uh, of not much cinematic merit, still they qualify for the copyright protection, because the artistic merit or the cinematic merit or the length or the duration of the work does not matter in the case of the copyright protection. You write a very bad poem, still you own a copyright on that bad poem. You do a bad performance, still you have a copyright on that performance. The only requirement in the case of the copyright is that your work must be original. Original here means that it must have originated from you and has not been substantially copied from any other person or any other source. So that is something very important to understand, that there must not be a copying, or you may say the work must not be substantially copied from anyone else's work. It must originate from you. If the work has originated from you, then it is yours, be it of a very poor quality. So, these are the examples. Now, we will talk in detail about the copyright in a short while, but let me conclude the different kinds of intellectual property. In the case of geographical indications, we have GIs which are given to the community, unlike, copyright and patent, which are available only to the individuals. GI or geographical indications are basically community rights which are given to the community. So we have examples of Muga silk of Assam, carpets of Mirzapur, Darjeeling tea, Meerut seizures. I would like to make a correction here. Basically, they applied for the protection under the GI category, but they could not get it on the Meerut seizures. But there is a community in the Meerut where they have the expertise of making very excellent seizures, which have durability, which are sharp, which are very efficacious, right? Which are far superior in quality vis-a-vis to the seizures manufactured or made in other parts of the country, but somehow they were not able to get the GI protection. These are the indicative things, I mean, over which you can get a patent, over which you can get a GI or geographical indication protection. This is again something very important for the academic institutions. In the academic institutions, many from or amongst us are such academicians or are such teachers of such disciplines who are aware about the usage of some products, manufactured goods, or you may say are aware of some food products. Some of the food scientists or people working in the food science discipline, or some of the people working in, you may say, apparel sciences, they all know that there are some, or they have the ability, or you may say they have the milieu or the background to understand that there are certain things or products which comes into the existence by the efforts of the community, and that is a long tradition, that there are products which have some sort of characteristics attributed to it, either because of the skilled labor of that particular community or region, or because of the climatic conditions of that region, or because of the soil characteristics, etc. So those things are protected under this regimen, or you can call those things are protected as geographical indications. So basically, the subject matter of GIs are food products, Tirupati Laddu, for example, Bengal Rasgulla or Odisha Rasgulla, right? These have been protected under the GI category, right? Or there are examples of manufactured goods like Moga silk, or handmade carpets of Mirzapur, etc. And food products, manufactured goods, agricultural goods like basmati or Darjeeling tea, right? So you as an academician in an academic institution have the onus or the duty of spreading the awareness, and if you are aware about any such kind of work which is peculiar to or peculiar of one community, which is something falling into the category of food product or an agricultural good or a manufactured good, then I would urge you as an academician to kindly exercise your, you may say, the intelligence, and to help that community out in getting the GI protection, because they will be able to monetize or commercialize their work once this GI gets conferred on them. I would urge you all to kindly see the works of people like Professor Gupta, Anil Gupta of IIM Ahmedabad, who runs an a very, you may say, noble endeavor he runs or he leads. It's called Honeybee Network. They help the ground root innovators, right? They reach out to the people, they identify the works of the people, they see the potential in the works of the people, and then help them and facilitate them in capitalizing them. So any one of us or amongst us can become a leader like him tomorrow if we take it seriously and if we understand the importance of it. And they also collaborate and help the individual grassroots innovator to collaborate with the industry, right? And the industry at times just takes a license of the work from the innovator, and then industrially applies it, and accordingly, pays the royalty to the innovator. And I have the examples of the innovators from the state of Punjab, from the state of Haryana, who have become, very rich and entrepreneurs just by having their collaboration with the industry. And they have also been identified and facilitated by the respective departments of the states, like Department of Science and Technology, or the patent facilitation centers across all states are now open, right? So they help them out. They help such grassroots innovators out in reaping the fruits of their works. If you see the examples of the industrial designs, so we have excellent designs of different things, like we have designs on t-shirts, we have designs on bottles, we have design of footwear, we have designs of furniture, we have designs of every single thing, of mobile phone, of laptops. Industrial designs are also important, and I know that there are institutions in India, in specifically in, if I talk about Haryana, we have a special university or a specific university running courses on designs. It's in Rohtak, in it's called Supwa. Its name is uh, State University of Performing Arts and Designs, or something like that. So there are institutions, academic institutions, primarily, where such designs, industrial designs, gets created by the students, by the academicians, by the research scholars, and they're worthy of the intellectual property protection. But we don't understand the importance of the same. So I have just jotted down, that in the academic institution, in the cases of specifically two kinds of intellectual property, patents and copyright, the problem is in the recognition. First and the foremost in the recognition, then in the protection, right? Recognition means the academic institutions usually don't lay out a crystal clear IPR policy. And this is where we fail as an academic institution. If we don't have a crystal clear IPR policy in the academic institution, our researchers, our academicians will never be motivated, or will not find a conducive environment to prosper and grow in a respective discipline. So it is something, very imperative, Dr. Angra, that we must have an IPR policy at place, and that policy must also recognize the endeavor of the academician, or a person working on the same. Usually what happens, the academia, in the academic field, the institution takes the whole intellectual property. It says that the IP lies within the institution, because the public resources or the institutional resources have been used by the individual or by the researcher. But that must not be the case. We must understand that in developed nations, the person who creates the work, even by using the public resources of the academic institution or the universities, it is that individual who gets the protection, not the institution, not the university, right? So this kind of a motivating policy or IPR policy has to be there in place in all the academic institutions. Then the another factor which is critical is the protection. You know, you need to understand that whatever work you have created, you need to protect it. If you can't protect it, you will not be able to help it.
Thank you, नमस्कार भाई सर, बड़े दिनों बाद.
Something happened.
Sorry,
Dr.
sir. You
Anuradha?
can go. You can continue, please.
Okay, okay. Fine, fine. I thought that somebody was interacting with me, so I stopped for a moment. Right. Well, yeah. So I was saying that understanding how to protect. So filing is one important aspect. You must file ASAP, or you may say as soon as possible. It is said in the field of patent specifically that the moment you think as a inventor of a work, that your work will be available, or will be concretely available, or it will get concretized, or will take an appropriate shape within 18 months of time, or within, you may say, 12 months of time, I must say, not 18, within 12 months of time, I think that you must file the application, because by filing the application for patent, you get the priority. Priority here means that it is your priority now to get the patent protection first on that particular work on which you have claimed the patent protection. If there comes any other person claiming a patent protection on a similar work or on the identical work, then since you have filed first, and all the jurisdictions in the world, they follow the regime of first filing. You know, one who files the application first is deemed as a true and first inventor. Though it is rebuttable that if there is someone who claims that it is him who created the work first, and somebody has just, you may say, has just stolen or taken away his work, or has usurped his work, then that particular thing is also allowed, that rebuttal is also allowed. But you must file it as soon as possible, or at the time when you think that your work is or will be ready within 12 months of time from the filing. You don't need to have the work ready at the time of the filing. You don't need to have the work fully ready for the work to be applied for the protection. You just need to have a blueprint of it with you, and the confidence of giving a concrete shape to the work within, you may say, 12 months of time. You will definitely get a patent protection on it if it qualifies all the requirements for getting the patent protection. So this is another important problem of not filing on time, which basically hinders or obstructs most of the people from the academia, because we usually don't have any legal counseling or help available at the level of the academic institutions. But on the contrary, in the case of industries, they have specialized legal teams and divisions to help them out in filing on an appropriate time. Then once you get the patent protection, the next question comes about the enforcement of the same. It has been seen and it has been noted that in the academic institutions, most of the times, the person owning the patent, or enjoying the patent protection, does not usually enforce the patent. What does enforcement here mean? Enforcement has got two dimensions here. One is that the person does not exercise, he sits idle on it, he does not industrially apply the patent and let the fruits of the patent reap or percolate to the society at large. And another is when it comes to infringement of his work. If somebody else is doing his or imitating his work or copying his work, then that person sits idle again and does not take an action of infringement against the individual, because he again does not have the resources. So for that, I will tell you that the government of India and the national IP policy of year 2016 as well as the new patent rules of year 2021, which have come on 21st of September, all help the academic institution, all facilitate the academic institution, or provide us a very conducive framework. If you refer to the latest rules of 2021 on patents, which came on 21st of September, for few days ago, right, or 5 days ago, these are giving us the exemption of 80% fee reduction in filing the patent applications. If any academic institution is filing a patent application, then they will have to pay only 20% of the fee of the total fee, which is an excellent, you may say, a step towards strengthening the patents coming from the academic institutions, or which is an excellent step towards nurturing the ideas which generate from the academic institutions, because usually it is also a challenge which is commonly shared by all the academic institutions, that the patent fee is very high and the scope of patent confirmation is very minimal. So why to spend that much of money? They usually give up their patents to some licensees, or they share their ideas to some XYZ people who later on monetize on those. So I tell you that now the fee is very less, and even that 20% is sometimes funded by the ministries, like if it is a computer science related, like a computer related invention, CRI or something, or if it is some other invention, it is usually taken up, or you may say, or funded by the ministries like Ministry of Electronics and Information Technology in the case of computer related inventions, or if in the case of Department of Biotechnology also has certain schemes of funding or facilitating, or paying you some amount. Even there has started a momentum in the country of late, or in the recent times, to even help the budding researchers and entrepreneurs by conferring them, or by granting them some specialized loans or money, right? Because you need money for giving shape to your work. You have an idea, but you don't have the resources, right? In the academic institution, we do get grants from different departments, but simultaneously the talk in relation to giving a capital to you on your venture, or on your idea, has also started in the country. Singapore is one jurisdiction where it started long back, and they are now pioneers in taking ideas as collateral or as securities, or as you may say, the banks over there take idea as a security, or a intellectual property as a security, and they confer you a bank loan on the same. So these are some of the possibilities which we have in this field, right? And we face some challenges in the same, which I have discussed to the best of my ability and capacity. Now I think I must open the floor for Q&A and for discussions, if there are any. I would like to interact with all of you, right? If there are any such questions, or any challenges that anyone faces, or any individual or any learned colleague wants to share, or take counseling on, I am happy to help.
Okay, thank you, sir. Thank you so much, sir, for such an insightful lecture. And I have given permission to all. They can unmute themselves and ask questions if any, or they can also put in the chat box, so we can have a small question answer session.
Hello.
Yes, ma'am.
हाँ जी, good morning. Good morning.
Good morning, ma'am.
सर, मेरा ये क्वेश्चन था कि जैसे आपने कॉपीराइट के बारे में बताया, या जो इंटेलेक्चुअल प्रॉपर्टी के बारे में जो भी एक इंटेलेक्चुअल पर्सन को करना चाहिए, ठीक है, जो बिजनेस पीपल दे नो कि कहाँ जाना है और कहाँ जाके ट्रेडमार्क अपना वो लेना है या पेटेंट कराना है, लेकिन मुझे लगता है कि एकेडमिक फील्ड में लोगों को शायद इतना नहीं पता कि हम कहाँ जाएं, किस जगह पे जाएं, कि किस प्लेटफॉर्म पे जाएं ये अपने राइट्स को एक्सरसाइज करने के लिए। प्लीज इफ यू कैन हेल्प। Thank you.
Can you also introduce yourself, Shushma ma'am? I mean, where do you work and which particular
मैं
district?
I am working as an associate professor in FC College Hisar, Haryana.
Okay, ma'am. Great to know it. Well, so far as this question is concerned, let me tell you, I have kept my video off for a moment. The reason is that I had to plug my MacBook with the charger, and I am finding that charger. But in the meantime, I am also answering your query. See, so far as this question is concerned, Shushma ma'am, where to go? As I told you that specifically in the case of copyright, because your question is pertaining to copyright. Let me tell you, there is an automatic protection in the case of copyright, first of all, right? The moment you create a work, like if you have, for example, written something, a literary work is there, you have authored a book, you get a copyright protection automatically. You, in the case of copyright, don't need to rush for a copyright protection. But as I said, and I repeat, that it is always advisable to get it protected, or a formal application for the protection should also follow or subsequently, and it should go to the patent office, or sorry, it should go to the copyright office. Usually the IP offices caters to several states, right? We have in our country right now, we have patent offices located in 4 different jurisdictions. So in our case, like if you are in Haryana, your application for the copyright protection should go to the patent office in Delhi, which is located at Dwarka, sector 14, right? It is called IP office or intellectual property office in Dwarka. बौद्धिक संपदा हाउस भी बोलते हैं उसको. आप वहां जाएं. आप सीधा खुद से नहीं जाना चाहती हैं, तो I would advise you that you take help of the concerned departments. Like there are ministries. In the case of patents specifically, patent facilitation centers have been opened by Ministry of Science and Technology of each state now. They have the patent facilitation centers. They facilitate people like us who are facing challenges. We can approach them. They would definitely help us out. These patent facilitation centers, by name or by terminology, they are patent facilitation centers, but let me tell you, they also help the academicians and the grassroots innovators and the researchers, inventors, entrepreneurs in filing their copyright, in filing their trademark, etc. So you may approach the said patent facilitation center of the Department of Science and Technology of Haryana, which is located in Panchkula. Sushma ma'am.
Thank you so much, sir. Thank you.
And let me add one more useful information to it. You now don't even need to move anywhere with the online filing of the trademark and online filing of the copyright, etc. has started in the country since 2017 and 2016, I must say, when we had first IP policy in India. The thrust of the government was on making it available to all parts of the country electronically, and now the trademark applications are filed electronically. The user interface is very friendly. If you go to the ipindia.nic.in, the website, you will find a lot of information. Even the tutorial videos are available: how to file your trademark, how to file your copyright, how to approach the patent office, etc. for patent filing, and so on and so forth, right? So electronic filing is also one very convenient option available at your disposal now.
Okay, thank you, sir. Thank you.
My pleasure, ma'am. Any other question or any other thing that someone is willing to share or discuss?
Thank you so much, sir. The dais is open for all. If you want to ask any question, you can ask, or we can go ahead. We can move further.
Okay.
Sir, the questions, there are no such questions in the chat box, and
Okay.
we'll mail you the
So
questions if there will be any, and you are with us till 30th, so we can ask again. And
yeah.
thank you so much, sir, for insightful lecture. And now I avail this opportunity to invite my colleague, Mrs. Nishu Bansal, NAC coordinator, for formal vote of thanks.
Thank you, Anuradha.
Thank you, ma'am.
Am I audible?
Yes, ma'am, you are very much.
A warm and cherished morning to our most valued Honorable Speaker, Dr. Ashwini Siwal, Madam Principal, Dr. Kiran Angra, my dear participants across the country. It is my proud privilege to propose a vote of thanks and acknowledge the contribution of those who worked hard to make this webinar a great success. I, Nishu Bansal, on behalf of M.D.S.D Girls College and the entire fraternity of the college, first of all, my sincere thanks to Almighty God for making today's event a great success. By His blessings and grace, we are able to make the event what it was. My sincere thanks to our today's speaker, Dr. Ashwini Siwalji, for giving an excellent coverage on IPR, patenting. Sir, you have beautifully explained copyright and trademark. And sir, we are very happy to know that we can get a patent by paying meagerly 20% fees or even less as guided by you. You have very beautifully clear all our doubts, and the chat box is full of compliments, sir. Thank you very much. I would take this opportunity to express my deep regards to our principal ma'am, accreditation ambassador, Dr. Kiran Angra, for being a constant motivator and guiding force in all our endeavors to excel in the field of education. My deep sense of thanks and appreciation goes to all the participants who are attending this webinar with great enthusiasm and made today's event a great success. Once again, thank you all. Thank you very much. Over to you, Anuradha.
Thank you, Nishu ma'am,
Thank you,
for
sir.
this great motivation and this elaborate vote of thanks. I would like to, I intervened here for the purpose, and the purpose is to tell that I have just begun and I have not concluded any of the intellectual properties and explanations on the IPR. We have 3 more sessions, to discuss it further, or
Yes,
I guess 2 more sessions to discuss it further, along with the very good speakers from the industry, who will be telling us the practical challenges that they face, with in collaborating with the industry and academia. I just, at the very beginning of the session, I told you that there are some challenges which I delineated or identified. But when we will listen them and take their views, I would be probably in a position to discern and comprehend along with you the challenges in nutshell, right? Or in more clarity. So I take this or extend my heartfelt gratitude, take this opportunity and extend my heartfelt gratitude to all the learned colleagues who joined us, specifically the worthy principal, Dr. Kiran Angra ma'am, who has been, available since morning with us, which is also very noticeable and unusual of a principal to stay for the whole discussion and the session and attend the whole session with us. I have usually seen that the principals and the leaders in the institutions, because of the paucity of time, they stay with us for 5-10 minutes and then they leave for their important works. But she is constantly there and listening us out. So thank you so very much, Kiran ma'am, for this kind encouragement and cooperation. And to Anuradha and Nishu Bansal ma'am. Thank you, ma'am.
Thank you so much, sir. Yes, Principal ma'am is always there with us, and she is our guiding light for every event. And I would like to inform participants that at 3 o'clock we are having FDP. Today is day 2. And at the same time at 10 o'clock we are having a webinar on IPR, and sir and other persons from industry and academia will be there with us. So I request all of the participants to join us at 3 today and 10 o'clock in the morning tomorrow. Thank you so much. So I have sent feedback form. You can fill the feedback form. Meeting is open for next. Yes, ma'am.
Anuradha, do tell. Thank you, Ashwini ji,
Thank you,
for
ma'am.
really a very insightful lecture.
Thank you, ma'am.
And yes, remind everyone that every morning from 10 to 12, we will be having sessions for IPR, Anuradha.
Yes,
and
ma'am.
from 3 to 5 on the other major criteria points of the NAC.
Right, ma'am.
Till 30th of September.
Right, ma'am. मेरी सभी पार्टिसिपेंट से रिक्वेस्ट है कि आज हमें 3 बजे शाम को ज्वाइन करें फैकल्टी डेवलपमेंट प्रोग्राम के लिए, और कल फिर से आप ज्वाइन करें 10 बजे फॉर IPR webinars. We are having webinars on IPR till 30th of September, and FPP will continue also till 30th of September. Morning session will be for IPR and evening session will be on different points of NAC. So have a nice morning to all of you. I have shared feedback link in the chat box. The meeting is open for next 15 minutes. Kindly fill your feedback. After that, you can leave the meeting. Thank you so much.
Dr. Anuradha, may I have the permission to leave now?
Yes, sir. Thank you so much, sir.
Thank you very much. Thank you,
Yes.
ma'am. Okay, thank you, ma'am. Have a good day to all of you.
Hello, Radha.
Yes, ma'am.
I want to leave now. I can leave it.
Yes, ma'am. You can leave. मीटिंग एंड हो चुकी है. सिर्फ फीडबैक फॉर्म जो लोग भर रहे हैं उनके लिए मीटिंग ओपन है फॉर नेक्स्ट 15 मिनट्स.
Excuse me, ma'am, Anuradha, ma'am.
Yes, ma'am.
Good morning.
Good morning.
Anuradha, I'm slightly confused. The morning sessions are not a part of the FDP. Is it like that? I just couldn't get it. Can you please tell me the program?
Yes, ma'am. Yeah, you are in which group, ma'am? IPR WhatsApp group or FTP WhatsApp group? You are in which group, ma'am?
I am not in the WhatsApp group, but I joined the FDP. But yesterday when we had the FDP session, so we were told that you will have a morning session as well. But now what? Yes.
Morning session is for IPR, ma'am, intellectual property right and industry academia best practices. It is not a kind of FDP. It is a kind of webinar series. We are having it daily, and we are providing certificates daily for webinar in morning IPR, and for FTP certificates will be provided on the 30th.
Okay,
right,
which means,
and after accumulating the attendance, if there will be 80% attendance of the candidate, will provide the certificate.
all right, okay, now I got it. Which means that those who are actually a part of the FDP, they may not attend the webinars. That is an option which they have, but it is up to them.
Right, it is up to them, ma'am.
Okay, okay. Thank you so much, ma'am. The FDP timings are same for every day, 3 to 5.
Yeah, 3 to 5 it is same, and for IPR also timings are same, 10 to 12.
Thank you so much, ma'am. Thank you, and you're doing a very good job. Congratulations.
Right.